For over a year, police were investigating homicide. They believed a particular individual was the getaway driver. So after 10 months, they decided to go into his home to search for his cell phone, which might contain some incriminating evidence connecting him to the homicide. Now, all of us have a cell phone, and it contains a plethora of information: where we go, who we see, and what we talk about. Now, anytime police are suspecting somebody of committing a crime, this device, your cell phone, might contain some incriminating evidence connecting you to the crime. But again, this is just a suspicion. There's a presumption of innocence, meaning that the person is just suspected of a crime. It doesn't necessarily mean that the person did it. Now the question becomes, does this mean that any time an individual is suspected of a crime, police can now go into his home to search for a cell phone which might contain some evidence connecting that person to the crime? Or do we need more? That is the question we're going to answer today. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Now that we're in the holiday season, the Do Not Arrest This Person t-shirt is a perfect gift for your family member who loves the Constitution and the Fourth Amendment. Thank you for watching. Let's move on.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Griffith, which is a case from the DC Circuit Court of Appeals. In the beginning of this video, I gave you some factual background, but let me fill in some of the gaps. As you already know, officers were investigating a homicide. The investigation took about 1 year. They believed that the shooting happened because of the rivalry between two gangs. Mr. Griffith, they believed, was a member of one of those gangs. They also believed that Mr. Griffith was the getaway driver. In the surveillance footage, they could see a vehicle leaving the scene. About 8 months later, officers interviewed Griffith's mother, who told them that her son was the principal driver of that particular vehicle that they saw in the surveillance footage. Now, during this whole time, while the investigation is pending, Mr. Griffith was incarcerated, doing a 10-month sentence on unrelated charges. But of course, the officers were surveilling all the calls that Mr. Griffith was making outside of his jail cell. They listened to 4 particular calls. 2 of them he made to his mother's house, 2 others he made to the grandmother's house, and on all 4 calls he was talking to another individual that the officers believed was also a gang member. During those phone calls, they discussed a whip, which of course is a slang term for a vehicle. After 10 months, Mr. Griffith gets released from custody. A 22-year veteran of the police department believes that Mr. Griffith was the getaway driver, and he wants to search Mr. Griffith's home because this police officer believed that inside the house they would find Mr. Griffith's cell phone, which would contain incriminating evidence connecting Mr. Griffith to the crime. Of course, whenever we discuss search warrants, which is what the officer obtained in this case, we have to look at the 4 corners of the search warrant to see whether it's valid. Just 2 sentences in the affidavit set out the basis for believing incriminating evidence would be discovered in the apartment. Those sentences read as follows: based upon your affiant's professional training and experience and your affiant's work with other veteran police officers and detectives, I know that gang members involved in criminal activity maintain regular contact with each other, even when they're arrested or incarcerated, and that they often stay advised and share intelligence about their activities through cell phones and other electronic communication devices and the internet, to include Facebook, Twitter, and email accounts. Based upon the aforementioned facts and circumstances and your client's experience and training, there's probable cause to believe that secreted inside of Lewis's apartment is evidence relating to the homicide discussed above. The affiant then concluded by enumerating the items the officers sought to seize from the apartment, particularly any cell phones and electronic devices found there. A magistrate judge granted the warrant, and a few days later, law enforcement arrived at Lewis's apartment. And by the way, Lewis is Griffith's girlfriend. They were living together at the time. Law enforcement arrived around 7 a.m. in the morning. They surrounded the building, and after 30 seconds of them knocking, Lewis opened the door. Officers walked in, but during the execution of the warrant, somebody tossed a handgun out the window. Of course, law enforcement knew that it was one of the three people who were inside, namely Lewis, Griffith, or a 6-year-old child. Inside the apartment, law enforcement also found a number of cell phones. Based on the seizure, Mr. Griffith is charged with being a felon in possession of a firearm in violation of Section 922G1. He challenges the search warrant, saying that the warrant was facially invalid because there was no probable cause to believe that he ever owned a cell phone, or an alternative, that any cell phones would be found inside the apartment. Before we go on, let's talk about the obvious. Before Mr. Griffith can challenge the search warrant, he has to demonstrate that he has standing under the Fourth Amendment. Even though this was Lewis's apartment, being a resident at this apartment, Mr. Griffith can demonstrate that he has a reasonable expectation of privacy in the place to be searched, namely the place he's living at, this apartment. And so, now that we know that he has standing, let's discuss the Fourth Amendment and its requirements. The Fourth Amendment prescribes that no warrants shall issue but upon probable cause. When assessing whether a search warrant is supported by probable cause, we ask whether the issuing judge had a substantial basis for concluding that a search would uncover evidence of wrongdoing. Although we pay great deference to the judge's initial determination of probable cause, a warrant application cannot rely merely on conclusory statements. In this case, the lion's share of the affidavit was devoted to establish Griffith's suspected involvement as a getaway driver in the homicide. And that information might perhaps be enough to support probable cause to get an arrest warrant to arrest Griffith. But here, the officers sought to obtain a search warrant. Now, search warrants are different than arrest warrants. The Supreme Court has long distinguished between arrest warrants and search warrants. An arrest warrant rests on probable cause to believe that the suspect committed an offense. It thus primarily serves to protect an individual's liberty interest against an unreasonable seizure of his person. A search warrant, by contrast, is grounded in probable cause to believe that the legitimate object of a search is located in a particular place. Rather than protect an individual's person, a search warrant guards an individual's interest in the privacy of his home and possessions against the unjustified intrusions of the police. The court identified 4 major issues with this warrant, and we begin with nexus. There must be a connection between the crime and the place to be searched, and the warrant, of course, has to particularly describe the items to be seized at that particular location. Which brings us to the second issue, ownership. There must be probable cause to believe that Mr. Griffith possessed a phone. Of course, we know from the introduction in this video and from the Supreme Court, and of course, general knowledge tells us that every single person, or just about every single person in the United States, possesses a phone. But when law enforcement are seeking to search a home for a cell phone, they have to show that this particular individual, Mr. Griffith, had a phone. And of course, we know that Mr. Griffith spent the last 10 months in custody. So the question here, would he still be possessing the same device that he had 10 months earlier when the homicide occurred? Well, we don't know that. And law enforcement didn't either. They don't have any surveillance to show that Mr. Griffith possessed a phone. They don't have any wiretaps where they can connect any communication to a particular device. We know that the only 4 calls that they had came from a landline from inside a jail cell to the outside Mr. Griffith's home and grandmother's house. So we know in this situation, there's no wiretaps and there's no surveillance that Mr. Griffith possessed a phone. And even if we assume that Mr. Griffith still had that device, it brings us to the third issue. Would that device be inside Mr. Griffith's home? Well, that's a good question. We know that most people carry their cell phones with them the second they leave their house. So why would Mr. Griffith be any different? You can safely assume that if Mr. Griffith is inside his house, he would have his cell phone on him, or if he leaves his apartment, he would take it with him. So we know this. If law enforcement comes to the home to execute a warrant and to arrest Mr. Griffith, of course they could search Mr. Griffith, his person, under what's called search incident to arrest. If they're arresting Mr. Griffith, they can search his pockets and presumably find his cell phone. There wouldn't be a problem. But here, that's not what happened. Instead, law enforcement sought a warrant to search not only Mr. Griffith, but the entire apartment. And not only for Mr. Griffith's cell phone, but any cell phone and any other electronic device, including iPads, computers, and so on. And there's really no evidence that any of those devices would be inside the house. There's no evidence that Mr. Griffith ever had not only his cell phone, but any other device. And we know that there's no evidence that those items would be found inside the apartment. And finally, the fourth major issue that the court identifies is that cell phones, unlike drugs, are not inherently illegal from outside observation, meaning that law enforcement are not interested in the cell phone, the device itself. They're interested in the information that's found within. So the question becomes, would 10 months later the information still be found on the device that would incriminate Mr. Griffith? Probably not. 10 months later, Mr. Griffith would most likely not even have the same cell phone, but most likely he would delete all the communications within the phone. So those are the 4 major issues that the court discusses. But there are other, of course, problems. The fact that the warrant was overbroad. Like I alluded earlier, rather than seeking a particular device, the warrant sought all cell phones or all communication devices inside the apartment. And of course, the warrants have to particularly describe the items to be sought and seized. And so this, of course, would violate that rule under the Fourth Amendment. So at the end of the day, all the items found inside the apartment have to be suppressed and cannot be used against Mr. Griffith. And as a final argument, you might be thinking, well, what about the fact that Mr. Griffith threw away the gun out the window? Did he, quote unquote, abandon the gun, and thus the Fourth Amendment doesn't apply? Well, that's a very good question, and the court addresses it. When we talk about abandonment, we assume that law enforcement is there legally. But if law enforcement are deemed to violate the Fourth Amendment, which the court said they did here, the warrant itself was invalid, and thus the search was also invalid, which means that law enforcement essentially forced Mr. Griffith into this particular conduct, meaning throwing away the gun out the window. Here's another example that the court gives. Imagine, for example, that police knock on a homeowner's door, falsely claim to have a search warrant, and then ask the resident to hand over all firearms when she comes to the door. She might comply, as the officers, by invoking a warrant, will have effectively announced that she has no right to resist their entry. Under the government's theory, there presumably would be no need to suppress the firearm because the officers would have obtained them without entering the home. The court rejects the suggestion that the admissibility of a firearms obtained by virtue of the officer's misconduct in such a situation would turn on whether they happen to have placed one foot inside the home. Instead, the Supreme Court has elsewhere explained that the person's Fourth Amendment interests in his home would be of little practical value if the state's agents could stand in a home's porch or a side garden and trawl for evidence with impunity. So once the police officers announce authority to search a home based on invalid warrant, the evidence relinquished by the individual inside based on the police officer's announcement has to be suppressed and cannot be used against that individual in court. So I hope you've learned something today about nexus, the connection between the crime and the place to be searched, and then just because officers have a warrant doesn't mean that that warrant is valid. Once we invalidate the warrant, all the items inside the house have to be suppressed and cannot be used against an individual in court. Which in this case, if the officers and the U.S. Attorney's Office cannot use the firearm in trial, this means that the whole case falls apart, because here Mr. Griffith was charged with being a felon in possession of a firearm. Without a firearm, there is no felon in possession of a firearm. I hope you've learned something. I hope you enjoyed this video. If you did, give it a thumbs up. If you're new to the channel, once again, subscribe to the LAWSTACHE channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out my merch, including the Do Not Arrest This Person t-shirts, hats, and other items. They're a perfect gift during this holiday season. And finally, if you've made it to the end of this video, and if you're still watching, give me a thumbs up in the comment section. This way I know you watched the whole thing and you support my channel. Thanks for watching, and I'll see you next Wednesday for another deep dive on a criminal case. Thanks for watching.